Now, at the most general level, every personal injury case can be divided between two phases. First, there is the pre-litigation phase, also known as pre-lit, and that phase is followed by the litigation phase, which begins with the filing of a formal lawsuit in a court of law. These are two separate phases, each with its own set of requirements and procedures. And with that said, most of the cases at our firm begin and end in the pre-litigation phase, meaning we are able to fully and successfully resolve the client's case without ever having to file a lawsuit, let alone take a deposition or have a trial. Pre-lit settlements are common in my industry, especially in car wreck cases. Sometimes, though, a lawsuit simply has to be filed. The defendant baselessly denies it did anything wrong, or the defendant's insurance company doesn't want to offer up enough money to make settlement work. Either way, when the other side refuses to play fair, our recourse is a lawsuit, litigation. More on that later. Going back to the big picture, we have pre-lit and litigation. Now, barring limited exception, your case is going to begin in the pre-lit phase and it's going to stay there a while. That's because it's in the pre-lit phase that you are going to be receiving and completing all of your medical treatment. How long is that going to last? Well, it depends on your injury. It could be 6 weeks, it could be 6 months. I'd be lying to you if we didn't have a fair number of cases here at the firm where the clients have been treating well over a year. Their injuries were just that significant. The point is, do not rush it. Your case is an injury case, and the most important evidence in an injury case will be your medical records for treatment received. If you rush through it or skip appointments, it's going to hurt the evidence, and thus it's going to hurt the value of your claim. You need to receive all medical treatment and do it consistently until you have reached your pre-accident condition or as close to it as medically possible. Please, please, please make it to all of your medical appointments. Do not skip any, because if you skip an appointment, what's that say? It says, I don't really need that treatment. And what's that say? Not really that hurt. Ding. Your case value just went down. So for your medical recovery and your financial recovery, that is the value of your case, do not skip any medical appointments. By that same token, if any of your doctors refers you to an outside specialist, maybe you're seeing a chiropractor and they say you need to go see an orthopedist, go see that specialist. Our office will help you make the appointment. Likewise, if your doctor refers you to go get MRIs or any other type of diagnostic imaging, go get the MRIs. Those MRIs and other diagnostic imaging are critically important. That is an objective view of what's inside your body. And without them, we're left really just at you and the doctor's word alone. Get the imaging. Liability insurance is like a big pile of money that you can only spend on one purpose: your injury damages. This is your one opportunity to get the treatment you need on someone else's dollar. The treatment that your own health insurance may not pay for down the road. And again, separately, I'll return to this point, your medical records are your best evidence in your injury case. The more treatment you receive, the better I can showcase your injury. And the better I can showcase your injury, the better the result in the end. Yes, I'm talking financially. Anyway, so you're going to be receiving and completing all of your medical treatment in the pre-lit phase. Meanwhile, what's our firm doing? Well, we're going to be opening up insurance claims with any insurance companies for the other side. If you don't know who the other side's insurance company is, we'll find them. We're also going to be doing early investigative work like obtaining witness statements, downloading police records, visiting the accident site to take photos, videos, measurements. And of course, at the beginning of the representation, we're going to assist you, the client, with coordinating medical treatment. You may not have health insurance, and that's okay. we will find you a high-quality medical provider who will not bill you up front for treatment. Now, I'm going to be straight with you. Our firm's duties during the pre-lit phase are not going to take nearly as long to complete as it is going to take for you to complete your medical treatment. Almost invariably, there is going to be a prolonged period of the representation where our firm is more or less in a holding pattern while we wait for you to finish treatment. I mean, that's almost every case. It doesn't mean that we don't care about you. It doesn't mean that we're ignoring you or sitting on our hands. It might mean that we're not doing anything but waiting, because what are we supposed to do if we have done everything that there is to do? However, we do want you to reach out to us while you are treating and let us know of any major developments in your treatment. And that's good or bad. If you miss a medical appointment, for example, we want you to let us know. If you're having a hard time finding a ride, we want you to let us know. If a doctor has referred you to go see a specialist, let us know. We would like to help facilitate that. And of course, the most important one, let our office know as soon as you have completed all medical treatment so that we may move on to the next step of the pre-lit phase, which is the collection of your medical and billing records for all treatment received. We call this step MRBR collection, for medical records, billing records, MRBR. Now, MRBR collection is, by and large, the part of the case that frustrates me most about PI. Under the current state of affairs, it takes providers an inexplicably long time to fill our medical and billing records requests. Incredibly frustrating. Have no idea why. But it's not uncommon for our firm to actually send out a records request and it take a provider 3 months to fill it. I'm not kidding. It's actually worse with the hospitals. Sometimes we'll send out a records request and it will take them 6 months to fill that request. 6 months. And it's for that reason that we try to request ER records as early as possible in the representation. Now, with respect to your other providers, your non-ER providers, we will not request medical records and bills until after you have fully completed treatment with that provider. And the reason why we do that, the reason why we wait, is a practical one. Think about how many records requests we would have to send out and follow up on if we sent out a records request every time you had an appointment. I mean, by the time we got the records for the first appointment, you would already have had a second or a third. Plus, if we sent one out after every single appointment, think about how easy it would be to accidentally miss one. And so we wait until you have completed treatment with that provider to request them all at once. All right, now your job. Once you have completed treatment with a provider, let our office know. Let's say you're treating with 5 different providers and you've completed treatment with just one of those 5, but you're continuing treatment with the remaining 4. Still, let our office know that you've completed treatment with provider 1 so that we can at least begin the process of collecting records from provider 1, and we'll get the remaining 4's records later on. Now, once you have completed your medical treatment with all of your providers, and once our firm has obtained all of the medical and billing records from each one of those providers, that is when we move forward to the next step of the pre-lit phase. And that next step involves our firm drafting what is known as the demand letter. The demand letter is your case and the amount of money you're seeking to settle your case in a nutshell. It tells the who, what, when, where, why of the accident that injured you. It also tells why, under applicable law, the defendant or the other side is liable for your damages. The demand letter also includes a very detailed summary of all medical treatment you've received, called a medical chronology. And the demand letter, lastly, includes an itemization of your damages. Now, the most immediate one that comes to mind is probably your past medical expenses. This treatment's not free. But it will also include in the demand letter any lost wages you have, any out-of-pocket costs. We also briefly touch on non-economic damages. Those are the more amorphous concepts, the stuff that we really billed on at trial, things like pain and suffering, mental anguish, physical impairment. Now, fair warning, in the pre-lit phase, insurance companies do not really like to give much value to the non-economic damages. That's more of a trial thing. And if we get there, that's where we're going to pour our heart and soul, all right? But just for present purposes, the demand letter will include mention of that. So it is important, as we're getting that together, for you to provide us with the meat for that demand letter, including the non-economic damages analysis. The way we do that is we have you tell us about your pain. Tell us about what are some of the different ways, specifically, that your pain has interfered with your life. What are some things that you could do before that you couldn't do after the accident, or that you could do without pain before the accident that you could not do without pain after the accident? It's important to be specific. And to this end, we advise, starting now, as you're watching this video, for you to get a journal, literally any sort of notepad, and keep a journal, what we call your pain diary, and to keep track of any events that where your pain or your impairment from the accident have interfered with your life. You would be so surprised how much of that stuff you'll forget by the time we get to the demand letter, let alone a deposition or trial. So keep track of it now. Memorialize it. It doesn't have to be a spiral. It can be in a notes app in your phone, but keep track of it. Please, it really helps us in that regard. Now, the demand letter is sent to the defendant and the defendant's insurance company. It's called a demand letter because our firm, on your behalf, is demanding that the other side pay a certain sum in exchange for your full settlement and release of your claims. And we will get that demand letter drafted. We'll do what lawyers do. And our firm will confer with you throughout that process and send you a draft of that demand. We will send you a draft of that demand, including the amount that's demanded, and we will have to get your approval to send that demand before we actually send it. However, I will say this, a couple things. In the demand letter, most of the time, especially auto accident cases, we're going to start with a policy limits demand. That means we are demanding every dollar on the other side's policy or on the negligent driver's policy. And really, a policy limits demand is a policy limits demand, right? Also, if we have a certain sum in the demand letter, remember, we're putting out our best day at trial numbers here. We might put a number in there that a jury, we'd be lucky to have them return it, but we're going to anchor high in the demand. And I don't want you to look at the demand letter and cement any certain expectations when it comes to the numbers. Sometimes we will anchor so high that I kind of have a hard time believing it. And so I will actually modify the number down, make a downward adjustment. So keep that in mind. The numbers in the demand letter, the amounts demanded, if it's not just a standard policy limits demand, those are really high. Don't anchor your expectations to whatever number is in the demand letter, okay? Once we send out the demand, applicable law requires that we give the other side a reasonable amount of time to evaluate and respond to the demand. And the law goes further to define a reasonable amount of time as 15 business days, so not including weekends, upon receipt. It may require more, depending on the complexity of the issues. So, as a general matter, for our standard cases like our garden variety car wreck injury claims, our firm gives the other side 20 days from the date we send it. So expect that once we send it out, to follow up with us in 20 days about what the other side responded. Now, when the other side sends their response to our demand, their response will look one of three ways. Number one, they will accept our demand and agree to pay the amount demanded. Number two, they will deny the demand altogether. Or three, which is the most common response, the other side will counteroffer a lesser amount to settle the case. Now, I mentioned response type number two. The insurance company may respond by denying our demand altogether. That is, the other side does not counteroffer any amount of money to settle the case, And if they do deny our demand altogether, it's going to be on one of two grounds. There are liability denials and coverage denials. So let's talk about the first one, liability denials. These are essentially when the other side says that based on applicable law, as applied to the relevant facts, the defendant, our insured, cannot be held liable for your damages. Liability denials are most often found in cases where there are disputes, word versus word disputes. There's not hard evidence placing blame or establishing facts. So we often see them, for example, in motor vehicle wreck cases where there is a wreck at an intersection. Driver 1 says that he had the green light. Driver 2 says that he had the green light. And there's no police report or other objective evidence to firmly corroborate one side or the other. That's where we see liability denials most often. It's a liability denial is essentially the other side saying the accident was your fault, or the accident was someone else's fault, not our fault. Those are liability denials. The second type of denial that I mentioned is a coverage denial. And these are a little more nuanced. These are based on the language of the policy. So let me try to simplify the concept. If we made a demand to the defendant's insurance company, and we're seeking the defendant's insurance policy proceeds to fund the settlement amount demanded, well, to get to that end, your claim has to be within the type of claims covered by the defendant's policy. For example, let's say that you are the victim of an assault. The defendant assaulted you with a hammer. And just for the sake of illustration, I know it's going to sound silly, let's say that based on that assault, we made an injury claim on the defendant's auto insurance policy. Their auto insurance policy. Well, auto insurance is intended for auto liability claims. It's for any harm caused by a negligent use of a vehicle. The policy is not intended to cover liabilities created when their insured goes and attacks someone with a hammer. So our claim would not be within the scope of coverage. So that's a silly example, but that's the idea. You also see coverage denials in cases where the defendant's policy has lapsed as of the date of the accident. So let's say you were in a car wreck and the defendant had an auto insurance policy listed in connection with his vehicle, but he had not paid his auto insurance that month and his policy had lapsed. Well, in that case, there's no insurance policy in effect to provide coverage. We would get a coverage denial letter back. Now, the good thing about that, I guess the most hopeful thing, is that we are typically told by the insurance company really quickly after sending the LOR whether there's a coverage denial or a coverage dispute. What's also helpful is that we often see cases start with a coverage denial, and when we try to press them for a copy of the policy or documents confirming the legitimacy of the coverage denial, we see them come off of it. They withdraw it. So not all hope is lost if you get a coverage denial letter back, okay? All right, so I've talked a lot about denials, and I really don't want you getting paranoid that your case is going to be denied. Look, that's the worst thing I can impress upon you, because then you'll get gun shy and you'll want to quit before this process really gets going. Denials are rare. They're rare. And rest easy because, well, for two things. Number one, our firm doesn't sign up losers. We don't sign up cases where we think there's going to be a huge liability dispute or where we think that the better argument is that our own client is at fault. We don't do that. We sign up winners. Second of all, if there's going to be a denial, whether it be on coverage or liability grounds, we usually hear about that well in advance of us sending out the demand letter. Usually we'll hear about it within a week of us sending the initial letter of representation to the other side. So don't worry about your case being denied. All right, so I mentioned actually the most common response that we get to the initial demand letter is a counteroffer for a less amount than the amount we demanded to settle the case. Once we receive that counteroffer, that is when we begin the next step of pre-lit, which I refer to as pre-lit negotiation. Pre-lit negotiation is usually conducted between our firm and insurance companies. Not the defendants themselves, it's their insurance companies. And insurance negotiations, well, they are unique from other types of negotiations. You may be a great negotiator with a ton of negotiation experience, but this has its own set of rules and conventions. All right, so I'm going to create a separate video explaining the nuances of insurance negotiations. But for now, let's just stick to the case roadmap, keep it plain Jane. All right. Now, some injury firms love to drag out the pre-lit negotiation process. Not here, not with me. At my firm, the pre-lit negotiation process is relatively quick because I'm of the philosophy that you'll know within 2 moves whether the other side is going to be fair. I'm also of the philosophy that once you know the other side is not going to be fair, that you immediately move the case into litigation. Otherwise, the way I see it, it's just wasting time. So like I said, I usually give the other side 2 moves, 2 counteroffers. If on the second counteroffer they're not even within the bounds of fair, I tell my staff to immediately contact you, the client, and schedule what we call the take to lit meeting, where we're going to discuss taking the case to the next phase, the litigation phase. However, let's hold off on discussing litigation. I'll do a separate litigation video because your case may not ever even see the litigation phase. If we're able to reach an agreed upon number to settle the case in the pre-lit negotiation, then we will move straight on to settlement. Now, at the most basic level, settlement involves the other side sending us a document called a settlement and release agreement. And that's going to specify the amount that the parties are settling for, and that in exchange, you are fully releasing all of your claims against the defendant and any other parties listed on the defendant's insurance policy. Our office will request that release agreement from the other side. They will send it to us. Usually that process doesn't take too long, maybe a couple days. Once we have the release agreement, we are going to send it to you along with a pre-disbursement accounting. Now, the pre-disbursement accounting is a line-by-line item breakdown of the proposed gross settlement amount, how much of that gross settlement amount will be allocated to the attorney fee, to case costs, to medical providers with expected reductions to those medical bills, any lien holders, and ultimately, at the very end, the most important amount, right? Your net amount, your in-pocket amount. So you're going to get a breakdown of that. We are going to need you to sign that, and we're going to need you to sign the release. Now, the release agreement is most insurance companies and defendants require that you sign that in front of a notary. You can find notaries at most banking branches, most libraries. You can find them at FedEx offices and UPS stores. And of course, you can find a notary here at the office if you want to come say hey and get it signed here. We'd love to have you. Now, once we have your signed pre-disbursement accounting and the signed and notarized release agreement, you will send it over to our firm. Our firm will then send that signed release over to the other side or their insurance company. And it's at that point that the ball is in the insurance company's court to cut us a settlement check. Now, it's usually not immediate. They usually don't cut the check the same day that they get the signed and notarized release. We found that it usually takes about 7 to 10 business days from the date that they receive the signed and notarized release to draft and mail out the settlement check. That settlement check will be sent to our law firm. Once we have it at our law firm, we will deposit that check into a trust account, an account called an IOTA. It's not our firm's money, right? That gross settlement is not our firm's money, not entirely anyway. That settlement is in the trust account. Only a portion of that gross settlement belongs to our firm. And in that trust, your funds are earmarked. While the funds sit in trust, we're going to be doing a lot of things. In fact, we really start doing this before we even get the settlement check. We're going to be sending out billing reduction requests to your medical providers, as well as to lien holders. The more that we can get any medical bills negotiated down, the more we can get any liens negotiated down, the more that goes to our clients. We want happy clients. We want y'all to refer future work to us. So we're going to do that, and we do that in almost every single case that we handle. That process usually is pretty quick with medical providers, not so quick with lien holders. And there are a bunch of different types of liens that we can see. Hospitals can retain a lien for the medical bill that the hospital retains. It's unique. They're unique, a unique type of medical provider in that respect. If you had you used health insurance to pay for any portion of your relevant medical treatment, and that insurance plan was governed by ERISA, we'll let you know if it was, then they can retain a lien. There are child support liens. There are Medicaid and Medicare liens. Those take quite some time to negotiate out. Now, the reason I'm telling you all this is because just because we have received a settlement check and deposited it into the trust account doesn't mean we're at the end of the road. You see, there is a distinct difference between settlement and the final step, which is disbursement. Disbursement is when we either cut and mail you your net in-pocket check, or you come to the office and we print it out, sign it, and hand it to you. That's disbursement. But between settlement, the date that we have agreed on a settlement amount with the other side, and disbursement, that can be a long period, especially when we have big third-party liens that are holding down the proceeds. It locks things down for a while until we can negotiate those out. But that's part of our job. And remember that. That's part of our job, and we're doing it for your benefit. There are laws that say we can get sued if we disperse an amount that after we've been provided with a notice of a lien. So we have to negotiate them out. And we're doing it, again, in large part because it benefits you. We don't want to just cut a check for the full lien amount if we can negotiate that lien down, right? I also want you to understand that we do routinely negotiate down medical bills. So while you're treating, I don't want this thought to be in the back of your head where you're concerned about racking up medical debt. We will negotiate those bills down. We will negotiate those bills down. Those bill-in reductions can be significant. In fact, you actually want the bills to be high going into the demand because they create a cushion. If you have high bills, well, those high bills are going to be considered in coming to a settlement amount, right? They will be considered in large part. That's the main item of damages that insurance companies look at. But after you lock in that settlement amount on the back end, if we get reductions on those medical bills, those same medical bills that supported the big settlement, well, those reductions, anything that we're able to free up, that's going to you. It's a cushion. High medical bills create a cushion for settlement. So do not worry about big medical bills. We will handle that for you. We're not going to leave you in the hole or even close to it. All right? Once we have had everyone paid off, we will, if the reductions are if we were able to get fewer reductions than we had anticipated in the pre-disbursement accounting, we will need to send you a new disbursement accounting that shows the new net breakdown for you to approve and sign. Once we have the signed disbursement accounting, we're ready to disperse. So make sure to, at this time, to keep us apprised of any new mailing address. If you have moved since we first began representing you, you got to let us know. Let us know what your mailing address is. And there you have it. That is the case roadmap, a condensed version of it. Hopefully this gives you some peace of mind as you're going into this process because now you know where things are headed. And really, it is pretty paint by numbers. A lot of this stuff is the same. We're going to be here every step of the way.